Hello viewers, welcome to my YouTube channel. So what we are going to be looking at today is whether a father or a mother can disinherit a child under a will. Whether a father or a mother can disinherit a child in a will. That's what we are going to be looking at today. And to answer this question, it is important for us to know whether the maker of that will is subject to Islamic law or the maker of the will is subject to native law and custom. And there are also other provisions of the will law of different states that also regulates this situation. And where a child is disinherited, is there any remedy for that child under the law? Is there anything the child can do under the law? These are the things we are going to be discussing in this video. So take a seat as we embark on this journey together. But before we proceed, please do well to subscribe to my YouTube channel. Hit the notification bell now. Thank you for subscribing. Let's proceed. If the maker of a will is a Muslim, the maker of a will is subject to Islamic law, that person can only dispose of 1/3 of his properties to outsiders, to strangers. The remaining 2/3 of his properties must remain, must be shared, must be distributed to his heirs, that is wife and children and probably other relatives. So as a Muslim, as someone that is subject to Islamic law, you cannot give more than 1/3 of your property to outsider. So where you don't like the faces of your children, or you don't trust your children to handle your property well in your absence, the only thing you can do is to give 1/3 of that property to trustees to help you manage. Yes, now you understand. And this has also been taken care of by different will law of different states. For instance, section 2 of the will law of Kaduna State and section 4 of the will law of Kwara State makes provision for this, that a Muslim man or a Muslim woman, someone that is subject to Islamic law, can only give 1/3 of his properties to a stranger, to outsiders. I hope this is useful. If you are finding this useful, please subscribe if you have not subscribed. Another one is where the person is subject to native law and custom. Where a person is subject to native law and custom is going to depend on the state that person hails from. For instance, for someone that hails from Edo State and the person is a Benin man, where the man wants to dispose of his properties, the house that he built and lived in during his lifetime must be given to his first son. Even though he does not love the first son, or the first son is someone that sells property at will and share the money to women, yes, the man does not have any option. He must still give that property to his first son. If he gives that house to another person aside the first son can go to court and court will rule in his favor. Court will give judgments in his favor. That's the case of Idehen and Idehen, Lawal Oshula and Lawal Oshula. You can also see section 3 of the will law of Edo State. Another important aspect again that we are going to look at is the section 2 of the will law of Lagos State. What does that section provide for? That section simply provides for a situation where the maker of a will fails to make reasonable financial provision for wife and children. So even though will law of Lagos State does not say you must give a certain percentage to your wife and your children, so where you don't like the faces of your wife and your children, or you feel they cannot manage your property well in your absence, you can give your properties, your companies, your houses, your cars to people you believe can manage them well, like trustees, right? You can give them to trustees. But in doing that, you must not forget to make reasonable financial provisions for your wife and your children. Where you fail to do this, your wife and your children can go to court within 6 months after the grant of probate for a court order to make reasonable financial provision for them. So if you are in Lagos, for instance, you can decide to where you don't like your children, or you feel they cannot manage your property well, there is nothing stopping you from giving the property to trustees to help you manage, right? And while you just make reasonable financial provision for them. What is reasonable financial provision? That is left for the court to decide. It is the court that will decide that, and in deciding that by the court is going to look at the circumstances. How have they been living? Yes, the kind of lifestyle they've been exposed to. Maybe they are used to going to Paris or Dubai for holidays. Yes, the court will consider all those things. I hope you find this video useful. If you do, please do also subscribe to my YouTube channel, share with your family and friends. So you know what to do now. Where your father fails to make reasonable financial provision for you, you can actually go to court within 6 months after the grant of probate. And as a father, as a mother, if you don't trust your children, there is nothing stopping you from actually giving your properties to trustees, like I've said. But if you are an Islamic person or a Muslim, you can only give 1/3 to outsiders. And if you are a Benin man, for instance, the house you built and lived in during your lifetime must be given to your first son. Thank you. Till I come your way next time, I remember myself.